The Labor Code of the Philippines, Chapter 3, Miscellaneous Provisions, Article 36, Regulatory Power. The Secretary of Labor shall have the power to restrict and regulate the recruitment and placement activities of all agencies within the coverage of this title, and is hereby authorized to issue orders and promulgate rules and regulations to carry out the objectives and implement the provisions of this title. Article 37. Visitorial Power. The Secretary of Labor or his duly authorized representatives may at any time inspect the premises, books of accounts, and records of any person or entity covered by this title, require it to submit reports regularly on prescribed forms, and act on violations of any provisions of this title. Article 38. Illegal Recruitment. A. Any recruitment activities including the prohibited practices enumerated under Article 34 of this Code to be undertaken by non-licensees or non-holders of authority shall be deemed illegal and punishable under Article 39 of this Code. The Department of Labor Employment or any law enforcement officer may initiate complaints under this article. B. Illegal recruitment when committed by a syndicate or in large scale shall be considered an offense involving economic sabotage and shall be penalized in accordance with Article 39 hereof. Illegal recruitment is deemed committed by a syndicate if carried out by a group of three or more persons conspiring and or confederating with an Illegal recruitment is deemed committed by a syndicate if carried out by a group of three or more persons conspiring and or confederating with one another in carrying out any unlawful or illegal transaction, enterprise or scheme defined under the first paragraph hereof. Illegal recruitment is deemed committed in large scale if committed against three or more persons individually or as a group. C. The Secretary of Labor and Employment or his duly authorized representatives shall have the power to cause the arrest and detention of such non-licensed or non-holder of authority if after investigation it is determined that his activities constitute a danger to national security and public order or will lead to further exploitation of job seekers. The Secretary shall order the search of the office or premises and seizure of the documents, paraphernalia, properties, and other implements used in illegal recruitment activities, and the closure of companies, establishments, and entities found to be engaged in the recruitment of workers for overseas employment without having been licensed or authorized to do so. Article 39 repealed by Republic Act Number 8042, Section 7. Title 2. Employment of Non-Resident Aliens. Article 40. Permit of Non-Resident Aliens. Any alien seeking admission to the Philippines for employment purposes, and any domestic or foreign employer who desires to engage an alien for employment in the Philippines shall obtain an employment permit from the Department of Labor. The employment permit may be issued to a non-resident alien or to the applicant employer after the determination of non-availability of a person in the Philippines who is competent, able, and willing at the time of application to perform the services for which the alien is desired. For an enterprise registered in preferred areas of investments, said employment permit may be issued upon the recommendation of the government agency charged with the supervision of said registered enterprise. Article 41. Provision against transfer of employment. After the issuance of an employment permit, the alien shall not transfer to another job or change his employer without prior approval of the Secretary of Labor. B. A non-resident alien who shall take up employment in violation of the provision of this title and its implementing rules and regulations shall be punished in accordance with the provisions of Article 289 and 290 of the Labor Code. In addition, the alien worker shall be subject to deportation after service of his sentence. Article 42. Submission of list. Any employer employing non-resident foreign nationals on the effective date of this code shall submit a list of such nationals to Secretary of Labor within 30 days after such date, indicating their names, citizenship, foreign and local addresses, nature of employment, and status of stay in that country. The Secretary of Labor shall then determine if they are entitled to an employment permit.